The number you have reached, 911, has been changed to a non-published number.
Hi there, welcome to Cltv. I'm your host, Ken Lammers, and this week we're going to talk about, well, preponderance of evidence, guilty beyond a reasonable doubt, actual innocence, and the presumption of innocence. All of which are concepts, ill-conceived, ill-defined concepts, and we're going to talk a little bit about how they all interplay. So the first thing we're going to talk about is, well, I want to give credit where credit's due. There are a couple of blogs which were talking about how a court, an appellate court out there, kicked back a conviction because they said there was insufficient evidence. And then, under a law, I think it was in Texas, the defendant tried to get his defense paid for by the courts because there's a presumption of innocence when you go to a trial court, and if there's a presumption of innocence and the evidence was insufficient, then he ought to get paid. And the court said, no, you don't get paid because it's not actual innocence, it's a presumption of innocence, or, insufficient evidence. So basically what I'm thinking here is what we've got are terms which come to us out of the past and are not well defined or ever going to be well defined. It's like dealing with philosophy, the way the courts work. They create these words, give meanings to these words which don't necessarily mean the same thing they would to a regular person, and then we have to deal with what happens when some of the definitions, such as innocence, are dealt with in the courts. So first of all, let's talk about start out by talking about the levels of proof and why the insufficiency of the evidence might not be actual innocence. So we start out with, and there are different proof levels. Start out with reasonable articulable suspicion. That's the, as we all know, that's the proof that the officer needs, the level of proof the officer needs to be able to pull a car over, to do a quick stop, do a little bit of a detention, to talk to somebody, ask them what they're doing, maybe do a pat down. Okay, so we get above that. The next thing we've got above that is going to be, probable cause, or PC, as you'll hear it talked about a lot of times. PC is, well, when there's actually some sort of reason to believe somebody did something. A little bit stronger than reasonable articulable suspicion. There's actually some reason to believe somebody did it. This is what you need for arrests. This is what you need for search warrants. It's a very low standard. It's what we use at the grand jury and during preliminary hearings and all that sort of thing. It's a low standard, pretty easily met. For fairly good reasons, at least for the cop on the street. We don't really need the cop on the street trying to decide whether or not somebody's guilty beyond a reasonable doubt every time he runs up on somebody. Because, well, it's just not practical. And, I'm not going to say impracticable because I think that's another thing that we do as lawyers. We use that word which means nothing to anybody else in the world except us. And means the exact same thing as impractical. So, an officer having to work above PC really is impractical. Next thing we get to is preponderance of the evidence. And you'll see that's a flat line, red line, and I'll get back to explaining why later. And we go up above preponderance of the evidence, and preponderance of evidence fills this gray area. And we get to, above that is, clear and convincing evidence. And I'll say what I've said to everybody. Well, no, I'll let it go this time. Every time I say that nobody's giving me a good definition, 3 people try to send me one and have not been convinced yet. But it's higher than preponderance, lower than the highest standard. And the highest standard is beyond a reasonable doubt. This is what we use in criminal law. We all know the platitudes which apply to it. It's better than 10 guilty men go free than 1 innocent man go to prison. So here's what we've got. This is all our proof levels. And the thing is that all of these are mushy. There is no solid definition, bright line definition that will fit every single fact pattern. You know, your best way of knowing whether or not there's probable cause or clear and convincing evidence, the best way of knowing is looking at the case law and finding, okay, you know, it was probable cause in this case, it wasn't probable cause in that case, and God help you if it's a case where, you know, there's some sort of evidence that has never been addressed before by the courts, because you're going to have to figure it out, and you aren't going to have a bright line to deal with. That's why all these lines are slanted, is because they can be, you know, tougher, less tough, depending on who's dealing with them and what goes on, and they don't really have solid definitions, except for preponderance of the evidence. Preponderance of the evidence has a solid definition, more likely than not. It is the 50% definition. If it is 1/1,000,000th of a decimal point above 50%, you've reached preponderance of the evidence, and it is, you know, that person is civilly liable. That's the civil liability level. And of course, beyond reasonable doubt is the criminal liability level, the criminal guilty level. And you can see that if an appellate court said there's not enough evidence, insufficient evidence, to find this person guilty beyond a reasonable doubt, it gets kicked down. But it does not mean it hasn't met the clear and convincing standard. It doesn't mean it hasn't met the preponderance standard. Now, beyond a reasonable doubt is beyond a reasonable doubt. You know, it is beyond any reasonable hypothesis of innocence. Okay, so there's this whole level in here where you can be liable for it, where, you know, yes, you did it. It's probably that you did it, but we're not going to find you guilty beyond a reasonable doubt. So we're not going to throw you in prison. You know, the most famous thing you're going to see out there for this was the O.J. Simpson case, you know, where he's found not guilty, and then, you know, he was found civilly liable for the death. You can exhaust your habeas route through Virginia and the federal courts, and then you have, I think, one shot at a writ of actual innocence. Writ of actual innocence, the person in prison has to prove their innocence, I think, to a clear and convincing standard. The only place I've seen this done successfully is with DNA evidence. And it may be done, there may have been a case or two where it's gone with, you know, recanting witnesses or something like that. But the only place that I know of is with DNA evidence. And there's a reason for that. And all of us that are honest with ourselves that work in the criminal justice system, you know, have seen witnesses recant, not for reasons of, you know, this person isn't guilty. They'll recant from family pressure. They'll recant from, oh my God, I didn't realize you can get 20 years in jail, prison pressure. And they'll, you know, all sorts of things like that cause it. You know, the mysterious witness who pops up 10 years later, who saw it all, and, you know, it didn't happen at all like it was said in trial. You know, after the primary investigating detective or the officer on the scene has, you know, moved to Tuscaloosa or Tucson, you know, and can't be gotten back. You know, these sorts of things make you very suspicious, and I think it's one of the reasons that DNA has really been the only way that people have gotten writs of actual innocence. And what this does then is, you know, Texas apparently passed a statute saying if you're found to actually be innocent, and I think they do it through habeas, but if you're found to be actually innocent, then, you know, we're going to pay you off. We don't have something like this in Virginia, at least not to my knowledge. You know, so this person in his original appeal, in which a appellate court said, no, that's not enough evidence for beyond a reasonable doubt. And then he tried to shoehorn that in with the presumption of innocence at trial, to shoehorn that into actual innocence. Because if you're presumed innocent, you must be innocent, and therefore I should get my money, you know, get paid. No, it doesn't work that way, and it's never going to work that way. There's going to have to be a higher standard for that sort of thing. Well, it doesn't have to be. General Assembly or the legislature can decide differently, but they're going to decide there's got to be a higher standard for that sort of thing every time. So what we've got is, let's say, you know, clear and convincing evidence that a person didn't do it, as opposed to just below, between 50% and you know, beyond a reasonable doubt. You know, there's just too much wiggle there. And the problem, of course, is going to be this: your appellate court is never going to say, we find this is insufficient evidence. We even find this is not even probable cause. If you got there, I think you got a pretty good case for saying actual innocence. But they don't do that. They just say insufficient evidence, shuffle it off to the trial court again to deal with, and that's the end of it. So you're going to end up with cases where you can't tell. You're never going to be able to tell. And that's why, and I think this, reading through the blog postings, that the Texas statute might actually require it to be on a habeas, but I'm not sure. Okay, so we start out, we've got this presumption of innocence instruction. I'm going to show you this one's Virginia's right here. Okay, so you've seen Virginia's presumption of innocence instruction. I disagree with this instruction. It's pretty bad. I mean, it's a fairly bad instruction. First of all, it tells jurors about something they don't really need to know about. You know, the whole, you know, if the whole, I mean, it tells the jurors about the safety valve part of the law. You know, we get through 98% of the trial, the jurors are back in the back, you know, contemplating whether or not they're going to find this guy guilty, and they've decided to find this guy guilty, and suddenly one of the people in the jurors' room has a heart attack, and they can't, you know, come back out and tell the judge before they can tell the judge. Well, then, you know, as a safety valve, you know, just in case maybe that was the one guy who was a holdout and the others are out willing to lie, whatever, we've got a safety valve which says, no, this guy is not guilty. You know, not guilty until proven guilty. And, you know, it'd be nice if we had a jury instruction that didn't tell we don't need to tell jurors that. I mean, that's just a function of the way the court works. That's a matter of law. What we need to tell the jurors is that they shall not be biased. You know, that's what we need to tell the jurors. And, you know, that, you know, start from, you know, empty slate instruction, basically, is what we need. Something along the lines of, you know, look, well, you can't really say that in a jury instruction. You know, you shall find no biases at the beginning of this case for either the prosecution or the defendant. At the beginning of the case, no evidence has been presented, and therefore nothing has been proven or disproven. At the end of the case, when you retire to decide the case, you shall at that point begin comparing evidence. If the prosecution has proven beyond a reasonable doubt that John Smith robbed the Pitcairn Bank, you shall find him guilty. You know, something along those lines. I'm sure someone out there can put it together better than I did just there, but, you know, a blank slate instruction is what you really need, or an empty cup instruction, or however you want to put it. You know, something which says you start out with nothing, neither side's shown anything, and you shall not convict unless the prosecution proves beyond a reasonable doubt. And then gives, you know, we always give the instruction, if you do not find X, Y, and Z is proven beyond a reasonable doubt, you shall find John Smith not guilty. That's instructed over and over again. That's just typical instruction. So where did this poor instruction come from? And you know, like I said, I'm going to assume this is pretty much across the states. It comes from, you know, back in the depths of time, and I don't know the history behind all of it. Maybe somebody out there who's a law professor has it a little bit better. And I'm sure somebody will throw it. It is a part of our grand legal tradition. Yeah, okay. You know, our grand legal tradition could probably use to be tweaked so that people get instructions that make more sense. Beyond that, you know, it's one of those things that's been around forever. And if you've read opinions from like the 1830s or the 1790s or 1780s, which if you're in Virginia, you might very well have had to, you will see, you know, opinions where judges who have an obvious, you know, stronger grasp of philosophy, theology, etc., like that, you know, writing opinions that show, you know, that they're actually trying to justify their opinion in a way that makes sense to, you know, the world at large and learned people, basically. As opposed to what we get now, where you get, you know, an appellate court goes, in Smith against Commonwealth 25 years ago, we ruled this. But Judge, that doesn't make any sense. We don't care. We ruled this. Precedent is uber alles. Yeah, okay. Frustrating things that we've all run into, I'm sure. But part of the problem in the old days was, while they might have been, you know, putting together much shorter and perhaps even, you know, more educated opinions, they were not as solidified in the terms as we are now. And so, you know, when they say presumption of innocence, they didn't mean, you know, they didn't have all this worked out about these are the various levels of proof, and, you know, they didn't have, they had guilty or not guilty, and they were equating not guilty with presumption of innocence. And you're presumed not guilty. And as we've worked out the system over the years, that's just not the way it works. So, you know, we really they've kind of screwed the pooch on us. We're stuck with this really bad old language that nobody's going to fix because it's been around since the beginning of time. And God help us if we tried to fix language like that that's been around for, you know, who knows. It could have been around since William the Conqueror. They're just not going to fix that. But it doesn't say things the way they should be said. It's not explained the way it should be explained. We're just stuck with it. One thing which we could do, and something that I haven't really, I know it's done in other countries, and I'm not sure, I think maybe Great Britain, and I'm sure somebody will correct me on this, but we could do 3 choices for the finder of fact, whether it's a judge or a jury. There could be guilty, not guilty, and innocent. And we could then go, you know, instruct the jurors that, you know, if they've met all these beyond a reasonable doubt, they are to find the person guilty of whatever crime. We instruct them that if, in your findings, you find that the prosecution has failed to show beyond a preponderance of the evidence these elements, then you will find the person innocent. And if you find somewhere in between, you should find them not guilty. So that would leave us with, you know, guilty up here, innocent down here, and in the middle, you know, the people who aren't, are somewhere in the middle. And I'd even be willing to go further. You can say it's 10 people have to agree to innocence as opposed to 12 finding guilty. Although I will say that Scott's post a while back where he's talking about how why do we use unanimous juries makes sense to me, but you know, they're not going to change that either, Scott. But I really think that this would be something that we really could use in our system. Guilty, not guilty, and innocent. And I urge you all out there who are professors and who might be listened to if you actually get yourself published in places that, you know, I'll never even go to, like Harvard or, you know, Stanford or some such place. Or if you're a judge out there, just to try to push for this. Or if you're from the General Assembly, I welcome you to my humble video blog and ask you to please move this into law. It would be very helpful, and it would help to sort out these sorts of situations. Anyway, I think that's it for this week. I hope I didn't ramble too much, and I hope it made sense. I'll see you next week, and who knows what I'll be talking about then. Have a good week.